I've gone ahead and compiled a list of 16 ways that Donald Trump's constitutional rights were violated in his trial in Manhattan, New York, by the Democrat judge who is presiding over the trial, and by the Democrat district attorney who brought these charges, Alvin Bragg. Also, why I am certain that the United States Supreme Court will overturn this verdict. The question, of course, is when. Appeals can take a long time. The Supreme Court should step in right now, immediately. And by the way, I'm no rah-rah Trump guy. In fact, I posted a video on this a few weeks ago. Yes, I certainly will vote for Donald Trump over Joe Biden, but I was for almost any Republican but Trump in 2016. First, I was for Scott Walker. Then I was for Jeb Bush. Then I was for Marco Rubio. And then, of course, I voted for Trump over Hillary Clinton. I was for Ron DeSantis in 2024 in the Republican primaries, but Trump crushed him like a gnat. I also like to think I'm pretty objective. Of course, everyone has their biases, but I try to be as objective as possible. If it were obvious to me that Trump had committed a serious crime, something other than some technical record-keeping violation, then I would certainly be for conviction. But it would have to be a real crime that the average person can understand and explain. And it's not even clear to me that he committed any kind of record-keeping violation. That certainly wasn't established by this trial. And it was certainly not established that he committed any kind of election law violation in 2016. Even legal experts, constitutional scholars, law professors, including legal experts on CNN, cannot explain what the crime is that he was convicted of.
What happened today when the parties were arguing about what the jury instructions should be and should not be absolutely blew my mind. I need to call this out. We collectively, prosecutors, are pushing the boundaries of due process here. The general back and forth in the courtroom today was the defense lawyers saying, Your Honor, please tell the jury specifically what the other crime is, right? Prosecutors have to prove falsified records for another crime. Defense lawyers were begging him. They have to know what the other crime is. And prosecutors were saying, no, let's keep it very vague and general. It's a bizarro world. I know that there is some aggressive reading of the New York statute that says, well, the jury doesn't really have to know what the other crime is. But to me, that suggests that the DA's office is hell-bent on getting the conviction now and worry about the fallout later.
If you're the defense attorney and you're making that argument about what the instructions can be and what this looks like for the jury, I mean, it could truly decide this verdict and what that jury walks out of that room.
Absolutely. And I think Ellie's description was exactly right, that prosecutors are asking for a very broad interpretation of what could be allowed. And at one point, you heard Emma Bovey, one of the defense lawyers, say today, you're leaving this so vague that one interpretation is that he could have broken a civil election law and that not even a criminal violation.
They don't understand what he was convicted of. Any objective person should be alarmed by what took place in that kangaroo court in Manhattan. I would not want to see this happen to any Democrat or any American. We're a country that is supposed to be under the rule of law. The law is supposed to be applied fairly and impartially. It shouldn't matter what your politics are. Every defendant in America is entitled to due process and a fair and impartial trial. Even Charles Manson, even Jeffrey Dahmer, even Ted Bundy. Every American is entitled to a fair trial. This trial was like something out of North Korea or Mao's China. So there are 16 reasons why I believe that this verdict will be overturned on appeal. And these reasons are not from me. These reasons I'm summarizing mostly from reading and listening to former Harvard law professor Alan Dershowitz and current George Washington University law professor Jonathan Turley. So these reasons mostly come from them. I just try to compile these reasons into an easy-to-understand 16-point list. Now, Professor Alan Dershowitz, he's a lifelong Democrat. He voted for Joe Biden in 2020. He voted for Obama both times. I'm pretty sure Jonathan Turley is also a Democrat, judging by his writings over the years. But these men are intellectually honest. I don't watch much cable news except to hear what the partisans are saying. On Fox News, you'll hear rah-rah Trump all the time. Meanwhile, MSNBC is, of course, ecstatic over the Trump conviction. But you can't get much in the way of honest analysis from either of these channels. To give some credit to CNN, CNN has been airing some criticism of the way this trial has been handled. For my legal opinions, I turn to Professor Alan Dershowitz and Professor Jonathan Turley. Both Democrats, but intellectually honest. Here's my summary of what they've been saying. Reason number one for why Donald Trump's constitutional rights were denied. Well, the judge in this case, a judge by the name of Juan Mercan, Well, he was a donor to the Biden for President campaign. He was also a donor to an anti-Trump, anti-Republican super PAC. In fact, this judge earmarked his donation to the anti-Trump, anti-Republican super PAC this way. He wrote that his donation is to be used for, quote, resisting the Republican Party and Donald Trump's radical right-wing legacy. And it's a violation of the legal ethics, the legal standards of the state of New York for a sitting judge to even be making political contributions. But he presided over this case anyway. This fact, no impartial judge, means that Donald Trump was denied his right to due process and a fair and impartial trial under both the 6th and 14th Amendments of the Constitution. I mean, imagine if this judge had been a donor to Donald Trump instead. Well, you know the fake news and Democrats would be in an uproar, would be demanding his removal from the case. But this judge, a Biden donor, and who is on the record as a Republican hater and a Trump hater, was allowed to preside over this case anyway. Incredible. Reason number 2. The judge's daughter, Lauren Merchan, is a professional fundraiser for Democrat candidates. She specializes in digital fundraising. Her political fundraising agency is called Authentic Campaigns. Her website boasts that she raises money for Biden-Harris. One of her biggest clients is Adam Schiff. During this 6-week trial, her fundraising agency raised more than $93 million for Democrats. Many of her fundraising solicitations were about this trial that was being presided over by her father, Judge Juan Merchan. In fact, her father, Judge Juan Merchan, reserved seats at the trial for big Democrat donors. Reason number 3 for why Donald Trump's constitutional rights were violated. The prosecutor in the case, Democrat District Attorney Alvin Bragg, campaigned on a promise that he would get Trump, that he would bring down Trump. Bragg's campaign for District Attorney of Manhattan was funded by organizations that are backed by the radical left billionaire George Soros, who has been focused over the last half-decade on electing radical left district attorneys. Now we see why. During his campaign for District Attorney of Manhattan, Bragg boasted about his, quote, Trump-hunting prowess, saying, quote, that it is a fact that I have sued Trump more than 100 times. That's how fanatical and single-focused Alvin Bragg was about taking down Trump. That's why he ran for district attorney. He boasted of having sued Donald Trump 100 times, more than 100 times, as his main credential for why he should be elected the top prosecutor in Manhattan. Now let's take a look at what the legendary Supreme Court Justice Robert Jackson wrote in 1940 about the duty of a prosecutor to apply the law fairly and impartially. And Justice Jackson, by the way, was a Democrat. He was appointed to the Supreme Court by Franklin Roosevelt. Here's what Jackson wrote, quote, one of the greatest difficulties of the position of prosecutor is that he must pick his cases. If the prosecutor is obliged to choose cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it is not a question of discovering the commission of a crime and then looking for the man who has committed it. It is a question of picking the man and then searching the law books, or putting investigators to work to pin some offense on him. It is in this realm in which the prosecutor picks some person whom he dislikes or desires to embarrass, or selects some group of unpopular persons and then looks for an offense. That is where the greatest danger of abuse of prosecuting power lies. That was Supreme Court Justice Robert Jackson, a Democrat. Obviously, Manhattan District Attorney Alvin Bragg fails every principle of justice outlined here by the famed Supreme Court Justice Robert Jackson. Alvin Bragg targeted the man, not the crime. He targeted the man and then searched for a crime. This is Stalinist justice. The chief of police for Joseph Stalin famously said this, "Show me the man and I'll find the crime." That's what Alvin Bragg did here. Alvin Bragg was hell-bent on getting Donald Trump no matter what. He boasted during his campaign for District Attorney of Manhattan that he had sued Donald Trump more than 100 times. And he told the voters of Manhattan that this is why he was best equipped to be elected District Attorney, so that he could focus on taking down Donald Trump. For Alvin Bragg, it was a question of finding any way possible to take down Trump, find any kind of technical violation, or failing that, just making up a crime based on made-up law. Bragg's open bias against Trump and his pledge to bring down Trump during his campaign before even investigating Donald Trump violated Donald Trump's rights under the 6th and 14th Amendments of the Constitution, the right to a fair and impartial trial, brought by a fair and impartial prosecutor. That was the standard that Supreme Court Justice Robert Jackson said was required of prosecutors, who have immense power, who have the power of the government. A prosecutor is an officer of the court, just as much as a judge is an officer of the court. They have a moral and legal duty, a constitutional duty, to be fair and impartial under the law, to apply the law equally. Their job is to prosecute crimes, not target people and then find a crime, or find some sort of technical violation, or failing that, making up a crime based on made-up law, which is what happened here. Reason number 4, and this might be the most outrageous. The judge instructed the jury that a unanimous verdict on each of the charges was not required. This is a criminal case. A unanimous verdict is always required in a criminal case. A unanimous verdict on each of the separate charges is required in any criminal case in America. So this is a standard I've never heard of even attempted to be applied in any courtroom in America. Never heard of that attempted in a criminal court. Alvin Bragg charged Donald Trump with 34 crimes, but almost all the charges involve the Trump organization labeling the famous $130,000 payment to Stormy Daniels, the hush money payment to porn actress Stormy Daniels in 2016, as a legal expense, and specifically as a retainer paid to then-Trump lawyer Michael Cohen. And this money actually was paid to Cohen, actually a lot more than $130,000. And then Cohen turned around and paid $130,000 to Daniels, paid her basically to go away and stop being a nuisance on behalf of Trump. Now, Daniels was claiming that she'd had sex with Donald Trump back in 2006 on one occasion. Nothing illegal at all with Donald Trump having sex with someone, but he denies having sex with Daniels. And beyond what Stormy Daniels is claiming, there's no evidence that Donald Trump had sex with Daniels. But it would not be illegal if he had. And I don't think anybody in America thinks Donald Trump is any kind of choir boy. And celebrities pay extortionists to go away all the time. And just because you pay someone to shut up and be quiet and go away does not mean that whatever this person is claiming is true. People make false claims all the time that are damaging, that are intended to be damaging. And rather than spend a lot of money suing that person, many businesses pay that person to just go away and stop talking. This is called a non-disclosure agreement. So this is a calculation that businesses make. Just pay the troublemaker to go away and stop making these false claims. And if anything, Donald Trump is the one that was the victim here, a victim of extortion, which is a felony. Extortion is a serious crime. So Alvin Bragg charged Donald Trump with falsifying business records in an effort to conceal the payment to this porn actress, this Stormy Daniels person, who Donald Trump calls horseface. Now, misdescribing or misclassifying a business expense is potentially a misdemeanor under New York state law, but the statute of limitations on this had run out. The only way that this could be brought back and elevated, kind of resurrected as a felony, is if it can be shown that the purpose of concealing this payment to Stormy Daniels was to further another crime, which would have to be a felony. There's no crime in having sex with Stormy Daniels, if that even occurred. No proof that it did. And there's no crime in paying Stormy Daniels $130,000 to stop talking about it. Non-disclosure agreements are entered into all the time by businesses, by celebrities, by politicians. Nothing illegal about non-disclosure agreements. The potential felony that Bragg came up with, or I should say manufactured, kind of made up, concocted, like a Frankenstein monster, was that supposedly Donald Trump defrauded the voters of New York in the 2016 election by not revealing to the voters of New York the $130,000 payment he had made to Stormy Daniels. So that was supposed to be the fraud, the felony. So I guess Donald Trump was supposed to hold a press conference or something to announce that he had paid this $130,000 to Stormy Daniels, according to Alvin Bragg's law. But of course, that's not how non-disclosure agreements are handled. Once you enter into a non-disclosure agreement, you're not supposed to hold a press conference and announce it. That defeats the whole point of the non-disclosure agreement. But that was the charge, defrauding the voters of New York in 2016 by not revealing this payment to Stormy Daniels. The problem with this is that Hillary Clinton won New York State in 2016 by 25 points. Donald Trump did not even campaign in New York State because New York State is among the bluest of blue Democrat states in America. But Bragg says the voters of New York were defrauded by not having a full picture of who Donald Trump is. And he claimed that this $130,000 payment to Stormy Daniels was really an illegal campaign contribution to Donald Trump's own campaign. According to Bragg, it's an illegal contribution by Donald Trump to Donald Trump's own campaign. The problem with that is that there are no limits to what a candidate can contribute to his own campaign. Donald Trump can contribute $1 billion to his campaign if he wants. Anyways, the Federal Election Commission had looked into this and had determined that this was not a campaign contribution and there was nothing illegal about it. So had the U.S. Attorney's Office from the Southern District of New York. They looked into it and said nothing illegal here. In fact, the District Attorney's Office of Manhattan looked into it twice and decided there was nothing there. Only after Donald Trump declared that he was running for president did Alvin Bragg decide to bring this set of charges that no one thought was criminal, that no one thought was even illegal, that no one even thought merited a fine. Miscategorizing or misdescribing something in your business records is a potential misdemeanor in New York State, but the statute of limitations on that had passed. So it really wasn't 34 charges. It was really 2 charges that Alvin Bragg was bringing. Number 1, incorrectly describing these business expenses, a potential misdemeanor for which the statute of limitations had passed, so that was 1. Almost all the charges were that. And then 2, defrauding the voters of New York by not alerting them to the $130,000 payment to Stormy Daniels. So the way that Bragg comes up with these 34 counts, these 34 charges, is by saying because this misdescribing or miscategorizing of business expenses appeared on multiple documents, well, that's how he comes up with 34 criminal charges. Even though these would all be misdemeanors, if tried and convicted, and even though the statute of limitations on these had all passed. So under Alvin Bragg's doctrine, each document where the description appears this way becomes its own crime. There was also a third charge that was suggested but never developed. The prosecution suggested tax fraud, but never established any facts behind this charge. The idea behind this charge is that possibly the $130,000 payment to Stormy Daniels was deducted as a business expense. That was never established and would not be illegal if it was, because protecting the Trump brand is a legit business expense, because the Trump brand is an important part of Donald Trump's business. So a non-disclosure agreement and payment to protect the Donald Trump brand would certainly be a legitimate business expense to deduct from your taxes. But that doesn't matter anyway because Donald Trump reimbursed the Trump Organization for the $130,000 out of his own personal funds, precisely so that it would not be a potentially illegal campaign contribution from his business, from the Trump Organization. That could be potentially illegal. But it wasn't really a campaign contribution anyway, as already established by the Federal Election Commission, which conducted its own investigation years earlier. The purpose of the payment can easily be to protect the Trump brand, but also to protect his marriage and his family from these claims from this porn actress. And the idea that Donald Trump would try to cheat the government out of taxes that he might owe on $130,000 is just absurd. He's a multi-billionaire. This is chump change for him. $130,000 is not even a rounding error in the scheme of Trump's personal finances or his business. Plus, he doesn't do his own taxes. His accountants handle his taxes. Also, there was no evidence presented at this trial that Donald Trump told anyone how to describe the $130,000 payment to Stormy Daniels. That was likely decided by his accountants or his lawyers. No evidence Donald Trump had any personal role in that. And very interestingly, the prosecution never brought in the CFO, the chief financial officer for the Trump Organization, to testify whether or not Donald Trump had instructed anyone as to how to describe the payment to Stormy Daniels. And that would have been Alan Weisselberg, who was the CFO for the Trump Organization. Weisselberg is serving 5 months in prison for perjury on another issue. But he could answer the question of whether anyone instructed him or anyone in accounting as to how to describe the payment to Stormy Daniels. And the accounting department and the legal department were probably the ones that decided how to describe this. I doubt Donald Trump had any involvement in that at all, how the payment was described. And there's certainly an argument that it is a legal expense. It's part of a non-disclosure agreement. It's part of a settlement, which is a legal expense. So in my view, not misdescribed, not falsely described at all. In business accounting, there are categories that you put things in, like legal expense, utilities, electricity, rent, categories like that. There's no category in a business accounting system, in a business ledger, for hush money to porn actress. And I suspect that the reason that the prosecution did not call Weisselberg, did not call the Trump Organization's chief financial officer to testify, is that what Weisselberg had to say would have torpedoed the prosecution's case. Probably would have said Trump knew nothing about how this expense was described in a business ledger. But why didn't Donald Trump's defense team call Weisselberg to testify? Well, likely because the prosecution would have had to grant Weisselberg immunity. Otherwise, he would just plead the Fifth and not say anything, because everyone has a Fifth Amendment right not to incriminate themselves. So the defense would not be able to get anything out of him unless the prosecution agreed to grant Weisselberg immunity. But Alvin Bragg and the prosecution was not about to do that, grant Weisselberg immunity. So he could testify that Donald Trump had no knowledge of how they describe business expenses. How business expenses are described is a job for accountants and tax lawyers. So the only one who would actually know if Donald Trump had anything to do with instructing accounting how to describe the payment to Daniels was not allowed to testify. Okay, so let's get back to reason number 4 for why Donald Trump's constitutional rights were violated. The judge instructed the jury that a unanimous verdict on each of the charges was not required. Unanimous verdict on the charges, not required for conviction. Not required for conviction. Let's say four jurors out of the 12 thought that Donald Trump broke federal election law. Let's say under Alvin Bragg's and Judge Merchan's legal scheme under their law, in their kangaroo court, let's say that 4 jurors thought that Trump broke federal election law. And let's say 4 out of 12 jurors thought that he falsified other documents. And let's say 4 jurors thought he did something else wrong. But there was no unanimous verdict on any one charge. But that all 12 jurors thought that, well, Trump did something wrong. He broke this law here, but not all of them agreed. Broke this law here, but not all of them agreed on that. And broke this law over here, but they didn't all agree on that. But pulled together, all 12 jurors thought that Trump violated one of these laws. Well, then, according to Judge Merchan's instructions, the jury would be obligated to convict, even if there's no unanimous agreement on any one charge. That's according to Judge Merchan's instructions. Everyone knows that the Constitution, the U.S. Constitution, requires a unanimous verdict in criminal trials, and that each charge must be considered separately. And there must be a unanimous verdict on each charge for there to be a conviction. So Donald Trump's constitutional rights were clearly violated by this judge's instructions to the jury. This judge's instructions were that if you think Donald Trump falsifying business records, for which there's no evidence that he did, and it's a misdemeanor anyway, and the statute of limitations had run out on that, if you think the reason he did that was to advance something else that was unlawful, which the judge did not define, then you must find Donald Trump guilty. That was his instruction to the jury.
What happened today when the parties were arguing about what the jury instructions should be and should not be absolutely blew my mind. I need to call this out. Defense lawyers saying, Your Honor, please tell the jury specifically what the other crime is, right? Prosecutors have to prove falsified records for another crime. Defense lawyers were begging him. They have to know what the other crime is. And prosecutors were saying, no, let's keep it very vague and general. It's a bizarro world.
If you're the defense attorney and you're making that argument about what the instructions can be and what this looks like for the jury, I mean, it could truly decide this verdict and what that jury walks out of that room.
Absolutely. And I think Ellie's description was exactly right. The point you heard Emma Bovey, one of the defense lawyers, say today, you're leaving this so vague that one interpretation is that he could have broken a civil election law and that not even a criminal violation.
And the judge's instructions were 29 pages long and were read to the jury. The jury was not allowed to have a copy of these instructions while deliberating. Now, normally in criminal trials, the judge's instructions to the jury are very simple, very easy to understand. Usually they're just a few paragraphs or a few sentences. Did he steal the money or not? Did he kill the guy or not? If the average person can't tell if something is a crime, then that's a problem. If the average person can't tell if something is a crime, then it shouldn't be a crime. Crimes are usually about stealing money, killing someone, or hurting someone. That's what most people think of as crimes. Not failing to hold a press conference to tell the voters of New York State about the $130,000 payment to Stormy Daniels. That's not a crime in most people's mind. Not holding a press conference to tell the voters of New York about this payment to Stormy Daniels. How is that a crime? So Donald Trump's constitutional rights were violated by this judge instructing the jury that a unanimous verdict on each of the charges was not required for conviction. And cases are overturned all the time in appellate courts by a judge's flawed instructions to the jury. I've never heard instructions from any judge to a jury that are so wrong on the law. This is just unheard of, baffling. This is Alice in Wonderland stuff. And of course, this judge knew this. He knew he was confusing the jury. 29 pages, read to the jury, not allowed to take the instructions into the deliberation room. This judge was basically ordering that jury to convict Donald Trump. And juries do tend to rubber stamp whatever they think the judge wants. So this jury didn't even understand what this trial was about. Bookkeeping errors and misdescriptions of business expenses and that kind of thing. Payments to porn actresses. They didn't understand what the legal issues were. No one did. All the jury understood was that this judge wanted Donald Trump convicted. Those instructions were just over the top a violation of Donald Trump's constitutional rights. Wrong instructions about the law to the jury. In effect, ordering the jury, I wouldn't say in effect, I would say almost clearly ordering the jury to convict Donald Trump. Reason number 5 that Donald Trump's constitutional rights were violated. Judge Juan Merchan is presiding over 3 Trump trials, 3 Trump cases. This records case, another Trump Organization case, and the Steve Bannon case. Steve Bannon was Trump's 2016 campaign strategist. Now, I don't know how many judges there are in Manhattan. I assume a lot. But judges for cases are supposed to be selected at random. It would seem to be a remote mathematical coincidence that Judge Merchan was selected for 3 Trump cases. If Judge Merchan was not randomly appointed, randomly selected, then this would be a violation of Donald Trump's constitutional right to due process. If a court jurisdiction has a set of rules, the rules have to apply equally to everybody. If judges are supposed to be selected at random, then they need to be selected randomly for every case. So the math alone tells us that the fix was in if this same judge was randomly selected to preside over 3 Trump trials. So then if the selection of the judge was rigged, obviously it was, how difficult would it be also to rig jury selection? Was there even one Republican juror on this jury? My guess is not. Manhattan voted 86% for Joe Biden. How tough would it be for Democrats in the Democrat-dominated government of Manhattan, the Democrat-run government of Manhattan, to make sure that only Democrats are selected for the jury? It would be very easy for these Democrat operatives working in the government of New York to make sure that Donald Trump had an all-Democrat jury. They could investigate the backgrounds of each of the jurors, see what their party affiliation is, look at their Facebook and social media posts, and so on. It would be easy for them to find 12 Trump-hating jurors. And given how desperate Democrats are to keep power and defeat Donald Trump, I would think rigging the jury selection for this Trump trial in Manhattan is almost certain. The stakes for Democrats here are just so enormous that there's no way that they're going to leave jury selection to chance. Now, I can't prove that, obviously, but I just can't imagine that these Democrats who run Manhattan would allow one Republican to make it onto the jury by chance, given their blind hatred for Donald Trump. Reason number 6 that Donald Trump's constitutional rights were violated. Donald Trump was denied his request for a change in venue for the trial. Now, normally, criminal defendants are allowed one change in venue. Under the Constitution, a defendant is entitled to be tried by a jury of one's peers. This is a jurisdiction that is 86% Democrat. The odds of getting a fair and impartial jury for Donald Trump in this jurisdiction is remote, especially if jury selection was rigged too, which I suspect it was. Donald Trump would have had a much better chance in the Bronx, in Brooklyn, Staten Island, Queens. Manhattan is the most liberal borough in New York City. He was denied his request for a change in venue. Reason number 7 that Donald Trump's constitutional rights were violated. Judge Merchan denied the defense their right to question each prospective juror. Now, usually the defense gets to question each prospective juror and object to jurors who demonstrate bias. Judge Merchan ruled that the defense could not question jurors. So this obviously violated Donald Trump's right to a fair and impartial jury under the 6th and 14th Amendments of the Constitution. Reason number 8 that Donald Trump's constitutional rights were violated. Donald Trump was prevented by Judge Merchan from putting on a defense. Judge Merchan would not allow a key Trump witness to testify on election law, this being a case about potential election law violations. The Trump team wanted to put on the former chairman of the Federal Election Commission to testify that the payment to Stormy Daniels was not a violation of election law, that nothing Donald Trump did in that regard was a violation of election law. There could be no better expert on election law than the former chairman of the Federal Election Commission, a man by the name of Bradley Smith, but Judge Merchan denied the jury the opportunity to hear from one of the nation's foremost expert on election law in a case about election law. Judge Merchan would not allow Smith to testify on election law, so the jury never got to hear from one of America's foremost experts on election law that Donald Trump did not violate any election laws by paying Stormy Daniels $130,000 and then not recording this payment as a campaign expense, since Donald Trump paid this out of his own personal funds. And it would not be a campaign expense anyway. Judge Merchan also cleared the courtroom at one point to stop the testimony of Robert Costello, who was the former deputy chief of the criminal division for the U.S. Attorney's Office in the Southern District of New York. Costello was there to rebut the testimony of the prosecution's key witness, which was the serial convicted perjurer, Michael Cohen. Michael Cohen, of course, was once Trump's lawyer, then became a convicted liar and tax evader and Trump hater. Reason number 9 for why Donald Trump's constitutional rights were violated. Judge Merchan allowed porn actress Stormy Daniels to testify for days about a sexual romp she claimed she had with Trump on one occasion in 2006. And whether or not this occurred has absolutely nothing to do with the legal matters in the case, which was a business record-keeping case and an election law case. Trump denies having sex with Daniels in 2006 or any other time, but it wouldn't be illegal if he did. For Judge Merchan to allow the prosecution to have her on the stand for days describing this sexual romp she claimed she had with Trump back in 2006 on one occasion was clearly purposefully designed to smear Donald Trump and prejudice the jury against Trump, as well as confuse the jury about what this trial is about. Jury's up there thinking, like, why is she on? Is it illegal to have sex with Stormy Daniels in 2006? Is that the crime we're talking about? But she was on the stand for days talking about this. Had nothing to do with the case. A business records case, an election law case. Reason number 10 that Donald Trump's constitutional rights were violated was that Donald Trump was convicted of crimes that he was never charged with. That's right. Donald Trump was convicted of crimes he was never charged with by Alvin Bragg. The Trump defense was never informed about what crimes would be used as the, quote, predicate crimes that would resurrect the records keeping, that potential misdemeanor for which the statute of limitations had expired. The Trump defense was never informed about the predicate crimes that might have occurred that would resurrect this into a felony. And the Trump defense never learned what these crimes were that Trump was being charged with until the prosecution's closing argument. And even then, it wasn't clear what crimes were being alleged in the closing argument.
The jury instructions are so important. They're crucial. They're the last thing the jury will hear before they disappear into that jury room to deliberate. And what happened today when the parties were arguing about what the jury instructions should be and should not be absolutely blew my mind. I need to call this out. We collectively, prosecutors, are pushing the boundaries of due process here. The general back and forth in the courtroom today was the defense lawyers saying, Your Honor, please tell the jury specifically what the other crime is, right? Prosecutors have to prove falsified records for another crime. Defense lawyers were begging him. They have to know what the other crime is. And prosecutors were saying, no, let's keep it very vague and general. It's a bizarro world. I know that there is some aggressive reading of the New York statute that says, well, the jury doesn't really have to know what the other crime is. But to me, that suggests that the DA's office is hell-bent on getting the conviction now and worry about the fallout later.
If you're the defense attorney and you're making that argument about what the instructions can be and what this looks like for the jury, I mean, it could truly decide this verdict and what that jury walks out of that room.
Absolutely. And I think Ellie's description was exactly right. It is absolutely true that prosecutors are asking for a very broad interpretation of what could be allowed. And at one point, you heard Emma Bovey, one of the defense lawyers, say today, you're leaving this so vague that one interpretation is that he could have broken a civil election law and that not even a criminal violation.
The Fifth Amendment to the Constitution states that no person shall be held to answer for a felony, for a crime, unless on presentment or indictment of a grand jury. In other words, you have to be indicted by a grand jury, and you have to be there has to be a list of crimes for which you're being charged with so that you can defend against these crimes. But this never happened. The Trump defense never received a list of crimes, these predicate crimes, beyond the record keeping. The record keeping, those are the 34 counts. Then there are these other vague crimes, which was like defrauding the voters of New York, violating election law in 2016 with this payment to Stormy Daniels. There was the record keeping potential violations, misdemeanors, that the statute of limitations had passed on those. So to resurrect those and turn them into felonies, they had to find other crimes. And the purpose of mischaracterizing the payment to Stormy Daniels was to conceal these other crimes that were not defined. Those were the so-called predicate crimes. So those crimes were never really defined. So those were theoretically defrauding the voters of New York and violating federal election law. But we know that the Federal Election Commission decided that Trump's payment to Stormy Daniels was not a violation of federal election law. But that was one of the charges that this jury was told to consider. So Donald Trump was convicted of crimes that he was never charged with. What's required under the Constitution and American law in every state is that all charges be listed plainly on charging documents. Trump was never formally charged with violating any campaign finance laws, state or federal. Never charged with these crimes by Alvin Bragg. But that's what he was convicted of. The Federal Election Commission looked at this and said nothing here. The U.S. Attorney's Office for the Southern District of New York looked at this and said there's nothing here. Even the Manhattan District Attorney's Office looked at all of this, looked at it twice, and decided there was nothing here to prosecute. Even Alvin Bragg himself looked at it and decided against prosecuting it first. He thought it was just a very weak case, thought he could find something else stronger to go after. So he declined to prosecute. Then when Donald Trump announced that he was running again for president, Alvin Bragg swung into action and brought these charges. And miraculously got this case before this corrupt Biden donor judge who has made it clear how much he hates not just Donald Trump, but all Republicans. This judge made his hatred for Republicans and Donald Trump clear when he wrote that notation with his donation to that anti-Trump, anti-Republican super PAC, where he writes that this donation is to be used for, quote, resisting the Republican Party and Donald Trump's radical right-wing legacy, end quote. That's the note that Judge Merchan wrote with his donation to this anti-Trump, anti-Republican super PAC. Reason number 11 for how Donald Trump was denied his constitutional rights. The lead prosecutor in the case, the one who was actually arguing the case in court, the lead prosecutor in court, so that wouldn't be Alvin Bragg, this is someone else. This was a man named Matthew Colangelo, who quit his prestigious job in the Biden administration at the Biden Justice Department as a United States attorney to work for Alvin Bragg, to make sure that Donald Trump was convicted. Because probably Bragg and his team of New York, Manhattan local prosecutors were not very skilled in election law matters. Now, to quit a prestigious job like U.S. Attorney, United States Attorney, to become a local prosecutor is a huge step down. It's a demotion, which speaks to Colangelo's fanatical determination to bring down Donald Trump. It also shows that the Biden regime was directly involved in this case in Manhattan, coordinating it, actually undertaking the prosecution, because probably Bragg's office was not equipped to handle this prosecution. And Colangelo, this former U.S. attorney for Joe Biden, had been following Trump around the country for years, taking on prosecution jobs, local prosecution jobs in cases against Donald Trump. This is a man who is obsessed with taking down Donald Trump, with targeting the man, not the crime, targeting the man and then trying to find some violation somewhere. As Justice Jackson said, rummaging through the law books and all the rules and regulations and finding something that can be contorted and twisted to pin on the man. That is Joseph Stalin's justice. That's not supposed to be happening here in the United States of America. That's not how our justice system is supposed to work. Colangelo's dogged pursuit of Donald Trump for many years over many jurisdictions is an obvious violation of Donald Trump's constitutional right under the 6th and 14th Amendment to an impartial and fair prosecution. Reason number 12, Donald Trump's constitutional rights were violated. The judge made the defense go first during closing arguments, and then was denied a rebuttal in closing arguments. Now it's the obligation of the prosecution to prove its case. Then the defense has an opportunity to rebut the case, to answer the charges. For Judge Merchan to require the defense to go first with closing arguments implies that it's the defense's responsibility to prove Trump's innocence. No, that's ass backwards. The burden is on the prosecution to prove guilt beyond a reasonable doubt. The defendant is always presumed innocent under American law. The burden is on the prosecution to prove guilt beyond a reasonable doubt. No sane or reasonable legal system requires the defense to go first in closing arguments. But this is how Trump's trial was conducted in Judge Merchan's kangaroo court. Reason number 13 as to why Donald Trump's constitutional rights were violated. Judge Merchan allowed the prosecution to mischaracterize to the jury what facts of the trial had actually been established. One of the prosecutors, named Joshua Steinglass, told the jury that it is an established fact that the payment to Stormy Daniels was an illegal campaign contribution. But that was not established at all. The defense objected. Then Judge Merchan overruled this objection. And Steinglass proceeded to repeat this false statement that it was established fact that Donald Trump had violated federal election law, when actually the Federal Election Commission and the United States Justice Department had looked at this and had decided that there was no violation of election law here. No violation of election law on the issue of the payment to Stormy Daniels in 2016. And no violation of federal election law with how the payment was recorded. So Judge Merchan allowed the jury to go into deliberations, having been told repeatedly by the prosecution, falsely, that there had been federal campaign violations by Trump and that this had been established as fact. No campaign finance violations, no election law violations had been established as fact against Donald Trump with regard to this payment to Stormy Daniels or how it was recorded. In fact, Alvin Bragg and his prosecutors never even charged Donald Trump with campaign finance law violations in the charging documents. Never even made it known that this was a criminal charge being levied against Donald Trump until closing arguments at the trial. And then Judge Merchan denied Trump's defense an opportunity to rebut this out of the blue false claim by the prosecution in its closing argument. And remember, Judge Merchan also prevented the Trump defense team from putting on their own legal expert who could have shown that there was no violation of federal election law by Trump. This expert being the former chairman of the Federal Election Commission, Bradley Smith. Judge Merchan would not allow this expert on election law, the former chairman of the Federal Election Commission, testify in a case about election law. And also, the state of New York has no authority to enforce federal election law. But jurors went into deliberations thinking it was their job to enforce federal election law. Furthermore, even if Trump's payment to Stormy Daniels, the $130,000, can be viewed as a campaign contribution, it could not have been part of a conspiracy to influence the election because reporting of this contribution would have to happen after the election, since this payment occurred right before the election. But again, the Federal Election Commission and the U.S. Justice Department had looked into this and found no basis to impose even so much as a civil fine, let alone bring a criminal charge on the whole Stormy Daniels payment issue. But this became a felony in Judge Juan Merchan's kangaroo court. Reason number 14 that Donald Trump's constitutional rights were violated. Alvin Bragg's office destroyed evidence. A paralegal from Alvin Bragg's office testified that 3 pages of phone records between Michael Cohen and the lawyer for Stormy Daniels named Keith Davidson were deleted from the evidence. Tampering with evidence is a Class E felony under New York state law. Reason number 15, that Donald Trump's constitutional rights were violated. Judge Merchan ruled that the prosecution did not have to notify the defense as to what witnesses were being called in to testify until the day before they were called. The prosecution also did not have to tell the defense what order witnesses would appear. This would make it nearly impossible, I would say impossible, for the defense to prepare adequately for each witness. Reason number 16 as to why Donald Trump's constitutional rights were violated. Michael Cohen was allowed to give his opinion on the law to the jury, was allowed to wax on for hours about his opinion as to what constitutes federal election law. Now, Michael Cohen is a convicted serial perjurer, a liar, lies about everything. But he was allowed repeatedly to tell the jury that Donald Trump had violated campaign finance law. Michael Cohen was supposed to testify about facts he knew about, not his view of election law. He's not an election lawyer. He's not there to explain law to the jury. The defense objected to this, but Judge Merchan overruled the defense, overruled the objection. And Michael Cohen was just allowed to keep repeating that Donald Trump had violated campaign finance laws, had violated election laws. Then Judge Merchan would not permit the defense to put up the former chairman of the Federal Election Commission, Bradley Smith, to rebut Cohen, to explain to the jury that Trump's payment of the $130,000 to Stormy Daniels was not a violation of election law. Michael Cohen also admitted on the witness stand that he stole $60,000 from the Trump organization and knowingly filed false documents. And though a convicted felon on other crimes, Cohen was never prosecuted for these crimes. Furthermore, Cohen also posted repeatedly on social media about how much he hates Donald Trump and how much he wants to see him in prison. He was also making millions of dollars from his book deals and his podcasts that focused on trashing Trump. That's how Michael Cohen makes a living. He goes on CNN and MSNBC and he trashes Trump to sell his book, Trashing Trump. That's his business. And he was the key witness for the prosecution. So that's your 16th reason why Donald Trump's constitutional rights were violated. Michael Cohen was allowed to wax on for hours about his opinion on election law to a jury when he's not even an expert on election law. As far as I can tell, he's not even a good lawyer. And you can almost put a 17th reason here, but this is not so much a violation of Donald Trump's constitutional rights, though it is that. It would be a violation of the constitutional rights of the American people, specifically of people who support Donald Trump. Judge Merchan has scheduled sentencing of Donald Trump for July 11th, which is just 4 days before the start of the Republican National Convention, which is scheduled to start on July 15th. So sentencing on July 11th, Republican National Convention on July 15th. This is just blatant election interference by Judge Merchan. Will Judge Merchan send Donald Trump to prison? Well, he'll probably look at the polls and see what's happening there, but I assume he will. I assume he will sentence Donald Trump to prison. Democrats have shown that there's nothing that they won't do to hold power and to get power. Now, I also believe that the CIA is deeply involved in all of this. After all, the CIA and the FBI worked with the Hillary Clinton campaign in 2016 to hatch the Russia collusion hoax. And they were stunned that that didn't work to defeat Trump in 2016. And when that failed, Democrats manufactured 2 impeachments, plus the January 6th insurrection hoax. So now they are trying 4 separate criminal prosecutions in 4 different jurisdictions, plus 2 civil trials. Now, of course, the Biden regime and Democrats know that this verdict from Judge Merchan's kangaroo court will be overturned by the Supreme Court. There's no doubt about that, if not earlier by a New York State appellate court, though that's less likely because that state is completely controlled by Democrats, and it's a very corrupt state. I mean, these Alice in Wonderland proceedings in Judge Merchan's courtroom just don't pass the laugh test. Even liberal Democrat legal experts are saying this on CNN. But Democrats don't care because what they care about is being able to bog down Donald Trump in these legal proceedings and being able to brand him for a period of time as a convicted felon, at least until the verdict is overturned, and that could take months. And what the Supreme Court really needs to do is step in now and fix this miscarriage of justice, because it's not just Donald Trump who is the victim. The victim is our constitutional system, our constitutional order. The American Republic is the victim here. The Biden regime and the Democrat Party are betting that enough Americans just aren't paying attention, aren't paying close enough attention. But if they hear that Trump is a convicted felon, well, that might be a bridge too far, so they might not vote for him, where maybe before they were thinking about possibly voting for him. So really the contest here is for that 5%, 10% of undecided voters, kind of low information people, who can be persuaded if they hear the words over and over again, convicted felon, really having no knowledge of the issues in this case. I hope Americans are smarter than that. Unfortunately, I don't have a lot of hope because most Americans are not very good anymore at critical thinking. And we can thank the destruction of education in America for that. Destruction of our education system by design. A pillar of setting up a totalitarian system is to dumb down the population. That's what our education system does. So we'll see what happens. The Supreme Court should step in right now, immediately. But also Judge Juan Merchan's waiting until July 11th to impose his sentence on Donald Trump is he's denying Donald Trump and his supporters the right to a speedy appeal. Because usually you need to wait for sentencing before you can begin the appeal process. Judge Merchan knows what sentence he's going to impose. He's delaying the sentencing to July 11th for a reason. And one of the reasons is to delay Donald Trump's ability to appeal the verdict. Now, again, I don't really like Donald Trump that much. I'm not a huge fan of Donald Trump. I think he has a lot of character flaws. I wish he would tone down his Trumpiness maybe 20%. You know, I'm a Reagan-style conservative. I was not for Donald Trump in the 2016 Republican primaries, was not for Donald Trump in the 2024 Republican primaries. I was for DeSantis. But if the American people reward the Biden regime and Democrats with the victory on November 5th, the American Republic is over. Because Democrats will just keep on using this lawfare strategy and fine-tuning this strategy to target and destroy anyone who gets in their way. If DeSantis had been the nominee, they'd be doing the same thing to DeSantis, maybe slightly different, coming at him with slightly different angles, but it'd be basically the same strategy. They're not going to stop with Trump. They're going to use this strategy against any Republican or anyone who gets in their way. I mean, they're using it against Robert Kennedy Jr. So whoever stands in the way of their political agenda, whoever stands in the way of them holding and gaining political power, they're going to target and destroy by any means possible. Lawfare being one of the tools that they use. And if they get away with this, well, I think freedom is over in America if they get away with this. America then just becomes a banana republic, another failed country. Wanda and I have started selling all of our properties and assets in preparation for the emergence of totalitarianism in America. We want to be able to get out of the country quickly if we have to. Because make no mistake, today's Democrat Party is totalitarian. This is not your grandfather's Democrat Party. This is not the party of Walter Mondale or Jimmy Carter. These people are totalitarian, Marxist, fascist thugs. They don't believe in free speech. They don't believe in freedom at all. Look what they're doing to Elon Musk. They're doing exactly to Elon Musk what they're doing to Donald Trump. I've counted 8 or 9 investigations by the Biden administration of Elon Musk, some of them criminal. Elon Musk is a combo of Thomas Edison and Henry Ford, and the Biden regime is coming after him with the force of government. They want to put him out of business. Why? Because he bought Twitter, because he wanted to save free speech. That's what Elon Musk wanted to do. Elon Musk has been a Democrat all of his life. Only recently did he start to rethink his affiliation with the Democrat Party, when they started coming after him for buying Twitter so that he could save free speech in America. You can also see the totalitarian nature of today's Democrat Party when you see how quickly they wanted to impose massive lockdowns during the COVID era, especially in the blue Democrat states. We had a few outposts of freedom, like in Florida and Texas and a few other places, but it was lockdown in Democrat states. And then it became lockdown again as soon as Biden became president. There was never any justification for the COVID lockdowns. And that was just a trial run for what they really want to do if they get their way, but a whole lot worse. That's why I'm doing everything I can to get Trump elected president on November 5th, even though I don't really like him that much.